Hi, everyone. Thanks for joining us today. My name is Alexander Villardo, and I'm co-chair of the Gold Group's Education Committee. Thank you all for attending today's CLE presentation, New York Speedy Trial in the Age of COVID-19 and Civil Rights Law Section 50A Discovery Update. This is one in a series of many virtual programs the Law Alumni Association and the Gold Group host as a service for our alumni and law students. If you are interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website. You can also listen to past CLE and other webinar recordings at no charge on our new alumni education webpage, also located on the law school website. To get discounts and select free 1-hour CLEs, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. Finally, I'd like to thank the Gold Group sponsors who have helped underwrite the costs associated with these events: Chicago Title, Council Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC, Paramount Settlement Planning LLC. Now, before we begin, a few brief administrative points. You will be muted during the course of the presentation. If you have a question at any time, please use the chat room, and Nick Romano will try to address the questions at the end of the presentation. At some point during the course of the CLE, the course code will be announced and also will be placed in the chat room. Please be sure to catch it, as you will need to put it on the online attorney verification form that was included on the registration page. This form is required to issue you your CLE credit. Please also return the program evaluation form found on that page. And at this point, I will turn things over to Nick Romano.
Thank you. I apologize. Can you hear me now?
Yes.
Thank you. Thank you, Alexander. Appreciate it. Good afternoon, everyone. My name is Nick Romano, and I'm a proud graduate of UB Law School and a member of the Gold Group's Educational Committee. It is my pleasure, my great pleasure, to introduce our speakers for today's CLE. First is Kevin M. Stadelmeyer, Esquire, Chief Attorney for Criminal Defense Unit of the Legal Aid Bureau of Buffalo, and Lori Hoffman, Esquire, Staff Attorney with the Legal Aid Bureau of Buffalo as well. These are two excellent criminal law practitioners in our area with extensive experience. As I noted before, Kevin is the Chief Attorney for the Criminal Defense Unit here in Buffalo. He's a proud graduate of St. Joe's Collegiate Institute, Niagara University, and University of Dayton School of Law. Kevin has practiced criminal defense in Western New York since 2002 and has been with Legal Aid since 2012. Lori is the managing attorney with Kevin at Legal Aid. She is also born and raised in Buffalo. She was a proud graduate of Orchard Park High School, SUNY Fredonia, and she is also a University of Dayton School of Law grad. We're not going to hold it against Kevin and Lori that they're not UB grads, but we know we're in good hands today. Lori has been practicing criminal defense since 2001, and she has been with Legal Aid since 2017. Without further ado, Kevin and Lori, take it away. Thank you.
Thanks very much, Nick, and thank everyone at the Gold Group for allowing us to come together today and give you this presentation. Just to give you a quick overview of how it's going to operate, Lori Hoffman has been on the ground dealing with a lot of these speedy trial issues, as well as a lot of the discovery stuff in her role as managing attorney, really being hands-on with our staff attorneys. So I'm going to sort of go through the presentation and give the 50,000 foot view. And Lori, as she's been doing to me for about 23 and a half years now, will interrupt me wherever she feels it's necessary to jump in and correct me or add color to what I'm trying to convey to you guys. As Nick said, Lori and I have known each other for a very long time. Went to school together at University of Dayton, and practiced together in Buffalo for many years, and have worked together at Legal Aid since 2017. And I think we're not understating it by saying, and I think many of you guys already know, that what we've been dealing with over the last year in terms of how our practice has changed and in terms of the things that have happened in the courts and in the criminal justice system are really unprecedented. It's nothing like we've ever seen before anywhere. And it required a lot of changes in how we practice. It required a lot of changes in how we administered our staff, dealt with our clients, managed our cases. And these two things we're going to talk about today are just two things that happened over the last year, but nevertheless, they are incredibly important and really kind of transformational in how things shook out. So I'm hoping everyone can see my PowerPoint presentation. I know you guys are all admiring it. It's fantastic. I spent lots and lots of time on it. I'm super talented when it comes to PowerPoint, as you guys will find out with all my amazing graphics and all this terrific stuff I threw in here. So without further ado, as Nick said, we'll go ahead and proceed here. So this is what caused this enormous mess that we've been dealing with since March 18th of 2020. That was the day that our office, like many offices, it might have been a couple of days before, a couple of days afterwards, were sort of forced out. That was the day the courts closed. We were notified late on the 17th, St. Patrick's Day of last year, that the courts would be closing the next day. We responded in kind by sending all of our people home. And basically at that point, we were in shutdown mode for several months thereafter. All we were doing for the first, at least 3 months, 4 months after the pandemic started, was in custody arraignments in Buffalo City Court for a while. Myself, along with another managing attorney, Michael Deal, were over in the court handling those in person. They had the clients at first coming into the courtroom for the first couple of days until they realized that was probably a really bad idea given how contagious this virus is. And then thereafter went to virtual court where the clients were at the jail. And that's continued even to this day. We still do our custody arraignments virtually. Our attorneys are either in their offices or at home on their computers. We do our arraignments virtually. So, the 18th happens, coronavirus invades, and we're really forced to pivot in how we practice. One of the first things that comes out once the state starts shutting down, so the courts shut down, and immediately the governor's office responds with an executive order. And it was an executive order 202.8. It was issued on March 20th, a couple of days after the court shutdown. And it's incredibly important that we kind of mark this date, because what this executive order did is it basically paused the very important criminal procedure law sections which govern speedy trial, which govern discovery, and really any time limits associated with criminal procedure law in the criminal justice process. So the things that did stop, obviously, CPL 3030, which governs how long the district attorney's office has to declare ready for trial on a case. We'll talk about readiness in a few minutes. It further paused any statutes of limitations. So if any cases were coming dead because they hadn't charged them yet, those time limits were stopped. So the district attorney's office, got a reprieve on having to file cases that they had been sitting on for a while, either because they hadn't completed their investigation or for other reasons. It stopped CPL 18080 preliminary hearings. As those of you who practice criminal defense know, if a client is charged with a felony and is kept in custody after arraignment, the district attorney's office has to run a preliminary hearing and present non-hearsay evidence within a certain time period, either 120 or 144 hours after that arraignment. And if they fail to do that, the client is eligible for the release on their own recognizance. And this pause order put a stop to those 18080 hearings, which is kind of a difficulty because you have clients who are charged sometimes even with low-level felonies that were sitting in custody for far longer than they ever would have, if the 18080 hearings were in effect. But we had to deal with that for several weeks after the pause went into effect until we were finally able to negotiate something with the judges in city court and the district attorney's offices and some other and the other courts around the area. Finally, and really importantly, in link to the 3030 issue, is CPL 245 mandatory discovery was paused. As many of you know, also in January of 2020, January of 2020, we got wide-ranging discovery reform, which required the district attorney's office to be turning over a vast amount of material within very short time periods after arraignment or after indictment. And it links to readiness, and we'll talk about how it links to readiness in a little bit, but it links to readiness because now, after the new discovery laws go into effect, the people cannot declare ready until they've provided all of this discovery in their possession, given excuses for why they haven't been able to provide other things, and they have to be, designated excuses under the statute, and then filed what's called a certificate of compliance, letting us know and the court know that they've turned over everything in their possession, or again, if they've got some good excuses to why they haven't turned something over. And it was only then, after the receipt by the judge in our office, and more importantly by the judge, that they were able to declare ready. But in any event, that 202.8 order issued on the 20th paused all of this stuff, and we really kind of went into an extended limbo with all of our cases, where we were basically just taking cases in and not doing anything with them. We were working very hard to get bail applications out on those cases that were subject to 18080 or 17070 for misdemeanor cases, or any clients that were held, even after the people were able to overcome 188 or 17070. So we're making the bail applications. We were meeting with our clients. We were monitoring, what was going on with our files, but really nothing could be accomplished. It was a full stop and completely unprecedented in my career, and having spoken to many people that predate me, it was completely unprecedented in just about anybody's career who's practicing criminal defense in New York. So let's just talk real quick about 3030 and 245, and Lori may jump in here, in a couple of minutes just to kind of talk about what was going on the ground. But 3030 mandates the time in which the district attorney must declare ready for trial in order to prosecute a criminal case. Following the commencement of a criminal action with the filing of an accusatory instrument, and that can be any number of things: a misdemeanor information, a violation information, a felony complaint, an indictment. They have to do certain things in order to become ready, and they have these time limits in which they have to do those things. So they have to become ready for trial in a case that's filed with the top count as a violation within 30 days of the commencement of the criminal action, 60 days on a B misdemeanor, 90 days on an A misdemeanor, and 6 months on a felony case. And I know some people are saying, well, why, Kevin, is it 6 months and for felonies and 90 days for violations and misdemeanors? And the answer is I have no earthly idea, and I wish to God they would change it to 180 days. It would make things a hell of a lot easier on us, not having to count the months. But they've never done that, and we're still stuck with that 6 month limit. But those are the time limits in which the people, under ordinary circumstances, from the filing of that accusatory, have to be able to declare ready for trial. And again, now that 245 has come into effect, it changes things a little bit. So the interplay of 245, like we said, in January 2020, due to these changes in the discovery law, it became a lot more difficult for the people to declare ready for trial. They had to, let's talk about prior to discovery reform. So prior to January 2020, it was incredibly easy for the people to declare ready for trial. They simply had to come in to the court and tell the court that we've met with all our witnesses. They're all available. We've submitted sufficient documentary proof to satisfy or at least make sufficient the charges that we filed, and we're ready for trial. And it was very difficult to overcome that. You'd have to actually, the burden would switch to defense counsel to have to make an affirmative showing that for some reason that readiness declaration was illusory. That we point to the supporting deposition and say that they haven't provided non-hearsay facts to support every element of the charges they're trying to levy against our client, or they've declared ready on some charges but not on others, and there's no such thing in the criminal procedure law as partial readiness. A very difficult barrier to overcome, and it more importantly didn't require them really to turn over anything to us prior to. So no discovery had to be turned over, really. Nothing had to be provided to us in terms of what's provided now for them to declare ready. And even worse, they didn't have to do it on the record. They could send us what's called a Kenzia letter. There was an old case, People versus Kenzia, which governed that the people could basically say, I'm ready, by sending us a letter in the mail in between court appearances, which is, again, very, very difficult to challenge. And at that point, as soon as they submit that Kenzia letter, mailbox rule, they mail it, the people are ready, and the time stops running. So that's an important thing to know. Once the people declare ready, that 3030 clock, unless we're somehow able to invalidate it or later go back and say that their readiness was illusory, it stops, the clock stops. And, we're not able to try and secure a speedy trial dismissal. Okay, so after discovery reform, so January 2020 happens after, like I said, the people are now required to turn over everything in their possession or give us, really good explanations as to why they haven't turned over some things prior to their readiness declaration. And it's not anywhere near as simple as it was before. Now, like I said, they've got to turn over all this discovery, and then they've got to file the certificate of compliance with the court and with us. And only after that's received by the court does 3030 stop. And there's a lot of challenges we can make to the COC, but it's a much higher bar than we ever had in place before. So the people are required to do a whole lot more work in order to declare ready. And this becomes incredibly important when we talk about what happened with 3030 and CPL 245 down the road. Okay, so what happened? So between March 20th, 2020 and October 5th, 2020, nothing happened. We weren't doing anything. We weren't in court. We weren't disposing of files. We were basically just arraigning in custody cases. For a little while in the summertime, about 3 or 4 weeks, we started the process of arraigning old appearance ticket cases in in-person court in Buffalo City. It was actually a little bit longer than that, about 8 weeks. Trying to take care of some of the backlog of the cases where officers wouldn't make an arrest because of the new bail reform. They would simply write an appearance ticket, but because the courts weren't open, those were just piling up. So the courts open for limited in-person appearances. Lori, do you remember exactly when that was? I want to say it was like in May of 2020, but it might have been just a bit earlier than that.
I believe it was May.
Okay, so it's in May. They open up for in-person. We start taking care of some of these, appearance ticket cases, but it didn't last very long because, as soon as the summer started to wane, the rates started to go up again. So while we're like under 1% community spread during the summer in Erie County, as soon as we got to like end of July, mid-August, the rates started creeping back up again and the courts closed down in-person appearances. So again, we weren't doing anything. However, through a lot of lobbying efforts done across the state by many different organizations, the New York State Association of Criminal Defense Lawyers, Bronx Defenders, a lot of the downstate big institutional providers, as well as our office, really going after the governor's office because we've got all these people sitting in custody, we've got all these cases that are piling up, and we need to start trying to move some of this stuff because we just started to get worried that if the courts decided to open, on a couple of weeks' notice, which maybe we weren't too scared that was going to happen, but in the event that they did, we were going to be dealing with so many cases and there was just going to be no possibility of us really handling that. So, and we also had clients who were sitting in custody with really nothing going on. And we wanted to try and, if we could resolve some of those cases, resolve them. So we pushed really hard and eventually the governor's office relented. And what we got was this. On October 4th of 2020, and this is another incredibly important date, and it sure was for our office, we had 202-67, and the clouds parted, and we had sunshine, and basically what this executive order did is it reinstated CPL 3030 speedy trial, which told the people that all these cases that you've got pending, the ones arraigned during the pause, as well as the ones that were pre-existing March 20th, the time started running on those again if they had not provided all the discovery and submitted their certificates of compliance. And more importantly, and I think something that was maybe missed by some practitioners that I talked to is that the 202.67 order reinstated CPL 245 discovery. And what we talked about a few minutes ago, those are inextricably linked now. You can't do anything with 3030, or the people can't do anything with 3030 in terms of stopping the clock unless they've turned over all the discovery in their possession, or again, made those excuses why they couldn't, and filed that certificate of compliance. So, as before January 2020, they could have just sent us hundreds and hundreds of Kenzia letters that would have been very, very difficult to challenge. They couldn't do that post 2020. And after this new order goes into effect on October 4th, and these two incredibly important statutes go back into effect, our office took note of that, and certain things started to turn here. So let's do the math. Without complete provision of CPL 245 discovery and a certificate of compliance attesting to readiness, CPL 3030 would expire for violations arraigned during the pause on November 5th, for B misdemeanors arraigned during the pause on December 5th, for A misdemeanors arraigned during the pause on January 5th. And then all cases that were arraigned before the pause that had their clocks stopped now had their clocks restarted. So any case that the district attorney's office, again, had not filed that certificate of compliance on, their clock restarted on October 5th. Felonies would have been April 5th, according to that 6-month rule, but the governor's office during November put a an additional pause on unindicted felony cases. So any
December
unindicted,
30th, Kevin.
November 30th. Thank you.
December.
So, I'm sorry, December 30th. My apologies. Thank you, Lori. See, you guys, Lori's always correcting me, which I love. I love it. Thank you, Lori. So on December 30th, the governor's office put an additional pause on those unindicted felony cases, which prevented us from making any 30-30 arguments on those unindicted felonies. And the reason for that is that the District Attorneys Association of New York was able to convince the governor's office that they had limited grand jury capacity because of the pandemic, and it was impractical to run virtual grand juries, which, you know, I can't help but agree with them on that one. I think trying to run a virtual grand jury would be incredibly difficult. But they were able to argue successfully that, you know, the pandemic created the situation that they couldn't bring enough people into the courtrooms to handle the volume of indictments. So they put a pause on all those files. The indicted felonies they didn't have to worry about, because once a case is indicted, 30-30 stops running anyway. So all those indicted cases just simply remained out. It's a tough situation. You've got a lot of people sitting in custody on those indicted files waiting for their trial. But that's neither here nor there for the purpose of this.
Well, so long as the people had properly declared ready with their COC after indictment.
Good point. Yes. If we somehow had a COC challenge to one of those indicted felonies, we could certainly make that motion in front of the relevant judge and hopefully maybe get an invalidated COC, which would then, you know, potentially start the clock running. Although whether it would be an indicted felony, an unindicted felony at that point, or whether we get an indictment dismissed, you know, we're not even going to get into that, because the felony stuff, it just really went by the wayside, and we dealt mostly with the misdemeanor cases. And just to give you guys another idea, you know, in the city of Buffalo and in the county of Erie, for those of you who don't practice in the county of Erie, the practice of indigent defense is split between two organizations: our office, the Legal Aid Bureau of Buffalo's Criminal Defense Unit, and the Assigned Counsel Program of Erie County. Our office gets all the non-conflict misdemeanors in the city of Buffalo, as well as a good number of felonies that are arraigned in Buffalo City Court that we keep and manage through the superior courts. The Assigned Counsel Program gets most of the rest of the felonies, so the A, B, and C felonies, out of Buffalo, and then they handle the municipal courts. What this means is that we're extraordinarily tuned in to these misdemeanor cases, and because it comprises the bulk of our caseload. So, you know, as we're reading that new 20267, our eyes kind of light up because of all these misdemeanor cases we've got hanging out.
Evan, if I can interrupt for a minute,
Absolutely.
I want to announce our course code is COURT, and Pat Warrington will put this in the chat as well. Again, our course code is COURT.
Thanks, Alex. Okay, so what did this mean? Oh yeah, Mr. Burns. Excellent. We started making plans right after the 202.67 order came out. Our management staff at the CDU met along with some of our staff attorneys and started to wonder what we might do with this new order. And I think it was relatively clear within a couple of minutes of us meeting as to what we needed to do. And the first thing we needed to do is we needed to start closely tracking what outstanding cases we had. So we immediately got in touch with all of our staff attorneys. At that point, most people were still working from home. They were in the office a little bit here and there when they had to be, but most of the time they were working at home, and all of our files were working at home because they're dutifully going through them, meeting with clients, doing as much investigation as they can, preparing for the day that we'd actually be back in court and could start disposing of these. So we got in touch with all of our attorneys, all of our staff attorneys, and said, hey, listen, start going through your files, anything you had prior to the pause and anything you picked up during the pause, and you know, put aside the ones where the people hadn't yet submitted their certificate of compliance. Then we started to have weekly meetings where we were going through those cases, developing lists of cases that we were dealing with, and furthermore, starting to review any of the discovery that came in, so that when the people actually got around to filing certificates of compliance on these cases, we were prepared to make COC objections so that we could keep that 30-30 clock running. So we were reviewing our cases weekly, we were developing our list, getting everything ready, and more importantly, we were preparing for the day that we would start filing 30-30 dismissal motions. We had a couple of attorneys in our office that worked extremely hard on drafting a 30-30 motion that was a little more crafted to what was going on during the pandemic, and really also trying to anticipate what the district attorney's objections might be for us filing 3030. There's a lot. When you read 3030, it's an incredibly dense statute. I think I provided a copy of it in the materials. And there's a ton of exceptions to the time that runs from the time that the accusatory instrument is filed or that the criminal action is commenced. And so, we have our attorneys reading through the statute, combing through case law, really trying to anticipate what the district attorney might do once we got around to actually filing these motions. And again, critically and really interestingly, because this is going to get interesting, at least it was for us at the time this happened, preparing mass filings of these 3030 motions. And when I say mass, we're talking in the hundreds, high hundreds, near 1,000 3030 motions that we ended up filing. And that's what I'm talking about. We brought in all of these cases, had our support staff come in. They had been working from home for the vast majority of the pandemic. We had them come in. We had attorney staff in the office daily, writing up all these motions, getting them prepared, and waiting for the day that we actually serve them. And when we served them, it was unbelievable. So let's talk about the DA response. So first of all,
Kevin, why don't we just pause there for a second and talk about some of the nuts and bolts of what happened on the ground.
Jump in.
So I think it's important to circle back around and talk about the fact that the Kenzia letter in the pre-January 2020 Declaration of Readiness was as simple as the district attorney's office sending a letter to any criminal defense attorney and saying, the people have completed their investigation, their witnesses are available, and we are ready for trial. That is word for word what is contained in a Kenzia letter. We had very, very little means of challenging that, short of having had communications with a complaining witness or a victim that told us that they did not want to go forward and that sort of thing. We could not even question the district attorney on the record as to whether or not they had spoken to their complaining witness or the witnesses. We could ask the court to inquire, and it was completely up to the court on whether or not to inquire at that point in time. The other thing to keep in mind is a declaration of readiness pre-2020, January 2020, and pre-245 did not require any type of discovery being handed over, except for what was required to convert the accusatories. 245 was 20 years in the making for New York State. 245 finally put us on the same level as 48 other states who had mandatory automatic discovery. We did not have that before January 2020. We had to file demands for discovery, and we had to list just about everything under the sun we thought we were entitled to. And half of the time, the district attorney's office just didn't turn it over anyways, believing that we weren't entitled to it. So January 2020 hits, and there is a mass issue with 245 discovery to begin with, pre-pandemic. We were fighting tooth and nail with the district attorney's office. We were getting their certificates of compliance kicked out based on objections of things that they weren't providing. So we were navigating the new 245 just prior to the pandemic. The pandemic strikes and everything is suspended. Literally nothing is happening. We have no time periods whatsoever. Like Kevin said, the only thing that's happening is arraignments because I'm stupid and have this weird obligation to the indigent clients we represent. I tell Kevin, give me all the cases. So all of the new cases that were arraigned in March, April, and May of 2020 were in my house, and I worked through all of them, including making notes on the discovery and the investigation and everything. But that was the only thing that was really going on, basically until June and July when things started to roll a little bit again. But at that point in time, no 3030, no 245 obligations, nothing. So we weren't getting anything. We were basically shuffling cases left and right. We turned the corner in October, like Kevin said, and the executive order comes out basically reinstating the 3030. At that point in time, like Kevin said, we were having weekly meetings at that point and gathering all of our case files. Now, the case files that I happened to keep were all arraigned during the pandemic. So it was easy. My 30/30 started on, October 5th. That was my first day. There were other cases that we had going on that are 2019 cases that had some 30/30 time expired. Then, there was a declaration of readiness that was nullified as of January 1, 2020, because the new 245. And we're not going to get into all of that. I just want you to understand that tracking cases is of the utmost importance. And we have to do that. And we're continuing to do that on cases. So if you're going to be dealing with any of these time limitations, you have to be aware. The other thing, and Kevin didn't put this up in the PowerPoint, and we probably should have, is if you do the math between October 5th and January 5th, it's actually 92 or 93 days. It was the 92nd or 93rd day because we had a holiday and a Sunday that alleviated the district attorney or actually extended their obligations, gave them an extra couple of days. So those are all things to keep in mind. But as of October 4th, when that executive order came out, we were having these meetings. We were taking note. So on January 4th, which was the last day for the district attorney's office to properly file a certificate of compliance on any A misdemeanor in Buffalo City Court, we waited and we got a bunch. I mean, we got a ton of COCs on that day, but we also had a ton that we didn't get on or we didn't receive. So on January 5th, our attorneys, based on our discussions and their obligations to their clients, filed 30/30 motions. And that's when Kevin said, all hell kind of broke loose, because then the floodgates opened and we are now in that situation where we're talking about what the DA's response was for having not complied with the 245 obligations in their COC obligations.
And just to be 100% clear, I mean, we were filing some 30/30s prior to January 5th, only because the time had run on this. So there were some violation cases that we filed 30/30s on. There were some B misdemeanors we filed. There were some that were pre-pause that we filed on, but the volume wasn't terrific. It was probably 30, 40, 50 cases. You would have thought that the district attorney's office would have sort of gotten the clue that they should start looking at a lot more of these cases that were arraigned during the pause. And I'm not 100% clear on why they never really caught on to the idea that they were going to have this major problem. As Lori said, they did file a good number of COCs in the days leading up to January 5th, but it was nowhere near. It was a small percentage of the total overall caseload and a small percentage of the total overall filings that we made. But what I'm not exaggerating when I tell you that
Kevin, your speaker went out. He has problems with his speaker. It only likes to work for about an hour at a time. So
right. Okay, you guys can hear me now?
Yes.
Yes, great. So now I think I've reset the clock for another round. So I'm not exaggerating that on the 5th, when we had everything ready and served it on the district attorney's office, we got some pretty panicked phone calls like, what do you guys think you're doing? Why are you filing all these motions? What is going on with these cases? And we said, well, I'm not sure what you're asking. I read 202-67. I'm thinking you probably did too, considering how many COCs you filed 3 days ago. I'm wondering where the disconnect is. In the coming days, we got a lot more communication from the district attorney's office. We had one district attorney's office tell us that our filing was an attack with precision befitting the military, because of how we were putting everything together and sending it over to them. But in any event, what ended up happening, and this really is where the rubber meets the road with how things have shaken out over the course of the last several weeks. They responded to our mass filing with a mass filing of their own. And typically when a district attorney is going to object to a 30/30 motion filed by our office, you're going to get a motion that's got a lot of canned language in it, but it's also going to have some particularized circumstances that they allege inside that motion. They're going to say, well, it's this because of this, or your client, came in one day and asked for a motions date, or you asked for a motions date, or whatever objection they're going to make. But in this particular circumstance, what they did is they filed this canned motion alleging just a blanket 3030G defense, which is that the pandemic and office closures was an exceptional circumstance which prevented them from doing investigation on their files. And we filed very quickly, turned around a counter brief. Because again, like I told you, we were busy during the pandemic and during the pause preparing for the idea that the district attorney's office might in fact allege exactly what they did allege, that 3030G prevented them from doing investigation, becoming ready and turning over discovery and whatever, which is exactly what they did. So we filed our reply brief. And again, there's a copy of it in the materials. I encourage you to read it. I'm not going to go crazy pumping up my staff attorneys, but it's a work of art. It was outstanding. It was very well done, well researched. And
Kevin and I had nothing to do with drafting it.
I had nothing to do with it. I will tell you right now, I had nothing to do with it other than I read it and I said it's fantastic. File it immediately. That's the 50,000 foot view. So in any event, please read that over. Feel free to use it if you've got cases. Use some of the language in there if you've got DAs in your cases alleging exceptional circumstances. I'm gonna let Lori talk about exactly what happened when we started to get these files in front of the courts and what the judges were talking about. And Lori, we don't have tons of time, but go ahead and hit the people out there with exactly what the judges have been saying and what our arguments have been.
Well, I'll actually, there's actually an addendum to this that has happened within the past 7 days after me and Kevin submitted our presentation. We filed our counter brief or our reply to the response. And what was happening is the district attorneys were coming in and basically arguing the exceptional circumstance adjournment. And it's important to remember that in an exceptional circumstance adjournment is an adjournment request. An adjournment request that's supposed to be made prior to the expiration of the 30/30 time. So we started with that basic argument. It's just an untimely argument. It's completely inappropriate and it's untimely. So the court shouldn't even entertain it. Some of the courts were still entertaining it. And basically what the district attorney's office was asserting was that due to the pandemic and their cutting of court personnel and court staff and their attorneys in office, that it had made it become very difficult for them to get the 245 requirements fulfilled. Our counter argument was telephones still work, computers still work. The Buffalo Police Department has been fully active for any body cam requests, any poll cam requests, any requests that are needed. And that essentially their lack of movement was more prosecutorial inaction than it was an exceptional circumstance. Since Kevin made this PowerPoint, several judges have dispelled the district attorney's application for the extraordinary circumstances adjournment, and it have been dismissing cases 30/30. An addendum to that is you also have a situation where they have not filed a COC at all. We make the straight 30/30 argument. We're now having the situation where COCs have been filed, and for lack of a better term, in some cases haphazardly, to get them in before the 30/30 deadline. And we are now challenging the sufficiency of those COCs or the certificates of compliance. Sorry, me and Kevin get into the use of the acronym because we use it so often, but the certificate of compliance, basically certifying that they have abided by their 245 obligations and have spoken to their witnesses and they're ready for trial. So we get these COCs that we believe are not properly filed, and we file our objections. And because they waited so long to file the COC, or because the objections were never properly answered by the people, we're also filing 30/30 motions attached. The district attorney's office has now filed, it would be a response to our reply to their response to our motion, basically asserting that we have to show prejudice for a 245 violation, and that dismissal should be the ultimate penalty, so to speak, in that there's various other penalties that should be afforded the district attorney's office instead of a dismissal. We have now had to do a response to that, basically asserting that they are confusing 245 and 3030. We are challenging the sufficiency of the certificate of compliance and essentially saying that it was illusory. And because it was illusory, 3030 has expired. We are not asking for sanctions for violations of 245. Sanctions for violations of 245 absolutely shows a showing of prejudice by the defense. We're not arguing that in the least little bit. So that is the latest wrinkle that we're dealing with that has now just come in front of the judges this week. I honestly don't think any judges have made any formal rulings as to that aspect of the people's argument. But the bottom line is they have been getting rejections from the court for their applications for the exceptional circumstances, and cases have been getting dismissed as speedy trial dead. This also did start another review of case files by the people for Buffalo City court cases. And basically what happened was all of the case files in Buffalo City court were gathered together and each one was individually reviewed. And we're not talking 30 or 40 cases. We're not talking 300 or 400 cases. We're talking in excess of 9,000 cases that came through Buffalo City court last year, which is actually about 4,000 or 5,000 cases lower than what we usually deal with. But all of those cases were reviewed by more senior district attorneys in the office, and that led to a compilation of a mass dismissal list, as well as a mass reserve calendar list. We have had approximately 600 cases that have been dismissed by motion of the district attorney in the interest of justice, based on everything that has happened over the past 2 months. Now, reserve calendar is kind of a legal fallacy. Basically, it's a mechanism in Buffalo City court that we use to control the flow of cases. So basically, if they can't go forward on a case, we have it put on this fake reserve calendar for a set dismissal date. That way we don't have to keep appearing in court. The district attorney doesn't have to keep, the case file open and whatnot. So as of right now, we have about 600 cases that have been dismissed or placed on reserve calendar. We have also had in excess of 300 cases, felony cases that have now been reduced to misdemeanors that they have started to move on. The downfall of this is we're still not moving cases fast enough. And we have clients that have been sitting in custody since March 16th of last year, which is the last full day of court. And it's still a fight. We're fighting tooth and nail every day to have the 180/80 and the felony, the felony 30/30 time reinstated. But this is basically where we're at right now for the 30/30. I know Kevin thought we were going to be done in like 30 or 40 minutes. I told him it wasn't going to happen, but so that's basically where we're at on the 30/30. And then Kevin, if you want to move on to the 50A and how that plays into everything as well.
Yep. And I just want to mention one other thing. It is highly unlikely that unless our office had been kind of on top of the pause orders and doing the math and preparing for this stuff, that we would be getting the dismissals that we're getting. The district attorney's office, isn't, while it's a good office and they have a lot of good prosecutors, they're not in the business of mass dismissing 600 cases in the span of 30 days. It's never happened. And I will tell you, and I would put money on it, that if we had not filed all the motions that we filed, they would never have been compelled to go and do the research on their cases that they did do. We never would have been having these huge compilations of dismissals. We would never be getting these reserve calendar lists on a weekly basis with the cases that are getting dumped. So it was really a lot of diligence. If given the opportunity to blow our own horn on this one, I will. Our office worked extremely hard on behalf of these clients to make sure that these cases were gone in any way, shape, or form we could get them gone. And it wasn't just for economy in the office or efficiency in getting cases that had been sitting for a long time moved. It was really for these clients who needed to have these cases dismissed off their records and had to have these cases gone. So I'm really pleased with the performance of the office and how we really managed this major issue and kept track of this stuff. And and certainly the things that have happened since then. We're still dealing with a ton of cases that the judges have reserved decision on. We're still arguing over some portions of 30-30 in exceptional circumstances, but for the vast majority of these cases, they're going to be dismissed eventually, either because the DA will have no choice but to dismiss them, or because the judges will dismiss them because it's the lawful and right thing to do. Okay, let's move on for the time we have left and talk about CPL 245 and the Civil Rights Law 50A repeal. First of all, what's 50A? Many of you may have seen the news over the last several years about 50A and what it really means. 50A was a statute that basically allowed municipal departments, including and most notably police departments, to withhold records that they felt shouldn't need to be released. And the only way you could get them released was by applying to a judge to try and get them released. And there was a very high bar that you had to meet in order to get them released. You could make FOIL requests and they wouldn't have to respond to them. Even if you were able to compel under like an Article 78, the judges weren't disclosing this information. And really it was done for the purpose, what the police agency said is that we shouldn't have to turn over every little penny ante, disciplinary proceeding we go through. Somebody comes late to work or, forgets their badge or something like that. We write them up. We shouldn't have to turn that stuff over. We should be able to determine on our own what's relevant and what you guys should have. And defense attorneys for years have been saying, hell no, we want to use that, in the context of trying to attack credibility on the stand. Anybody who does criminal defense knows, or at least should know, that people believe police officers. Judges believe police officers, jurors believe police officers. And if you're not able to impeach credibility of a police officer with outside things or things in the case, which sometimes are difficult, it becomes very difficult to win those types of cases when all you're left with is the only evidence you have left anyway is the word of a police officer that your client did something wrong. Your client's the one on trial. The police officer is somebody believable. It's only natural that we lose a lot of cases that way, or had lost a lot of cases that way. So for years, criminal defense lawyers have fought to try and get 50A repealed so that we could get at these disciplinary records. And finally, on June 12th of last year, after, again, lots of work, we finally got a 50A repeal. It was signed into law by the governor's office, and it was really, a day to celebrate because we were going to start getting all this information. There were still some hurdles to overcome. First of all, Public Officers Law 86-6 was amended to make all of these records discoverable. And they don't specify exactly how they were discoverable, just that they were discoverable. But we interpreted that in the context of CPL 245, and actually it's CPL 245-21K, to mean that any records in the that were relevant to the case, that were in the possession of a police agency, were then discoverable under 245, and not just discoverable, automatically discoverable, which is an incredibly important thing, which means we didn't have to make a motion to get them. The district attorney's office, in sending their discovery to us in advance of them filing a COC for readiness, had to turn them over. At least that was our argument. Now, right after 50A gets repealed, there's a bunch of lawsuits that are filed because immediately, news agencies, defense agencies start sending FOIL requests and subpoenas to police agencies to try and pull all these records, because not everyone read immediately that they were, automatically discoverable under 245. And even if they were, not every request was due to a criminal case. There were some civil requests that were made. Again, news agencies, Buffalo News, TV news, they wanted to get some of these records to complete investigations that they had started on officers, or to obviously have news stories on the repeal of 50A. So, where we didn't have a criminal case, they had a FOIL or subpoena. And that prompted lawsuits from the Sheriff's Department, Buffalo Police Department, saying, no, this is not what it means. You can't have everything. You can't have it for every reason. And some of those lawsuits are still pending. But what does this have to do with discovery? So in the context of a criminal case, again, we started making the argument pursuant to CPL 245-1K, as well as the people's obligations under two important United States Supreme Court cases, Brady and Giglio, which deal with exculpatory material that the people have in their possession, which tends to exculpate your client, that they had to turn this stuff over. So, under Brady and Giglio, if the people had, some evidence in their possession that a police officer had in the past been disciplined for lying an affidavit, or had been in the past disciplined for unlawful arrest, or bad behavior of any kind that somehow impacted the case that you were dealing with, that they were required to turn that over pursuant to Brady and Giglio. Prior to that, it was very difficult to get that information, even under those two statutes. But now, with the repeal of 50A, we were really able to use that repeal as a tool to start to get them to understand that they had to turn that material over. So we argued that under 245-21K and the changing of the public officers law of 86.6, that material is specifically discoverable because it's in the possession of law enforcement, and under 245-20 sub 2, because it's in the possession of law enforcement, it's imputed to be in the possession of the district attorney's office. The DA's office can't simply say, hey, we don't have this stuff. BPD's got it. They won't turn it over. Under the statute, under the new revised statute, that no longer flies. If it's in the possession of the police, it's just as if it's in the possession of the district attorney's office, and they've got to turn it over. So we started getting COCs, and a lot of people have been getting COCs with just passing reference. There's some disciplinary stuff. We'll give it to you at another time. Or, we're in the process of obtaining it, but we're ready on everything else. Here's everything else you're supposed to get, and we're ready. Well, we started challenging that, and other attorneys started challenging that. The DA's office was saying that, the information's foilable. You can get it by subpoena, so they shouldn't have to turn it over. It's not automatically discoverable. 1K doesn't apply to the situation. 86.6 doesn't mean what it says in the plain language, which, we argued was total bunk. That it absolutely means that it's absolutely automatically discoverable, that you 100% have to turn it over, and failure to do so does not allow you to file a valid COC. So let's talk about what's going on in Erie County. We've again been making all these COC objections. There's been some litigation again on, there was an Article 78 filed on a FOIL issue. I think that case may still be pending. I don't want to tell you it is or it isn't, because I don't know for sure, but I know that one was filed, several actually, and I want to say at least one was pending at the time that this PowerPoint was done. And very importantly, and in your materials, there's a written decision from County Court Judge Susan Egan on a case, People versus Cooper. Brittany Penberthy, who is a very well-known criminal defense lawyer in Buffalo. She's the president of the Erie County Bar Association's, or the chair of the Erie County Bar Association's criminal law committee, or co-chair anyway, had a case with Mr. Cooper. And in that case, the people filed the COC and just made passing mention of some disciplinary records that were linked to one of the officers, the arresting officers in the case. And then they would get them to her when the police turned them over. That they've got them, and they'll give them to her at some point. Well, Brittany said, no, you won't. You'll give them to me now, because if you don't, your case isn't ready, your COC is invalid, and in this case may be dismissed. Judge Egan heard that argument. Oral arguments were made, written arguments were made, and ultimately Judge Egan, in kind of a landmark decision in Erie County, sided with Ms. Penberthy and found that those records are automatically discoverable under 1K and 86.6, that the police have to turn them over to the district attorney's office, that they are imputed to be in the possession of the district attorney's office because they're in the possession of the police, and their failure to turn them over is absolutely grounds for invalidating their declaration of readiness on their COC. I don't know the status of this case, whether it actually went dead. I haven't talked to Brittany since I put this PowerPoint together, but I'm going to follow up with her and find out as to what's actually going on with Mr. Cooper's case. This decision, I don't know what's going to happen with it. There's reasonable, it's reasonable to think that the district attorney's office wouldn't want to appeal it, because if they do appeal it, it goes up to the appellate division. If the appellate division sides with Judge Egan, that's even better for us, because then we've got a fourth department decision which says exactly what we want it to say. But for right now, this is the law of the land in Erie County. It's good persuasive authority, and we've been using it to invalidate COCs where the district attorney's office is not turning over automatically these disciplinary records from these officers. So in addition, we've been compiling this material. So whenever it comes in now, so since we've got this decision, I think, Lori, you'd attest to this, so we're getting a larger volume of disciplinary records from the district attorney's office. We're getting disciplinary cards, we're getting records, we're getting decisions of internal IAB proceedings. We're getting, good summaries of things that had happened on other cases that officers were involved in. We've had cases dismissed outright because the DA's office just didn't simply want to turn over that material to us. They just said it's not something we want to disclose right now, which has been great. We're getting dismissals on behalf of our clients, but we continue to compile that information. We've got an internal police accountability project that we manage here in the office that takes all this information in and provides it to our staff attorneys for use in cross-examination of officers during hearings and trials. We're working with the National Association of Criminal Defense Lawyers on a disclosure project. They have an application that they've been providing to defense agencies around the country. And we're linking up with them to try and get that application for use with our staff attorneys in the courtrooms. So it's really kind of an exciting time, this new material that's coming in that's allowing us to impeach the credibility of police officers. I think it can only be a good thing ultimately for the police as well. I mean, I think in any profession, you'd like to be thought of as honest and trustworthy, and you'd like to be thought of as an organization that's ferreting out corruption and ferreting out bad actors, so that the public can have confidence that if you make an arrest, that it's on the level, that it actually happened for a good reason, and that the person that you've arrested at least is going through the criminal justice system in a way that is legal and lawful, rather than having the public, having your confidence, the public's confidence in you undermined because you've got bad actors and people doing the wrong things and violating constitutional rights left and right. This really, I've argued long that 50A and the repeal of it could only really be a positive thing. So just to kind of wrap this up, and Lori's texting me, wrap it up, Kev. I know, we had a bet. I said 45. She said, I've seen your closing arguments. They go way longer than that, you jerk. There's no way. So this is just be on the lookout. Now, I use BOLO. It's a term of art in law enforcement since we've been talking about the DA's office and police. So BOLO and wrap up. So carefully track time limits for any case arraigned during the pause. All you guys out there who have private cases or any of the institutional providers of indigent defense on the call. I think I saw Jerry Ader on the call. How you doing, Jerry? If you guys haven't been tracking internally your time limits, and I'm sure you have, go back and track. And that means any case arraigned before the pause that you haven't received a COC on, and any case arraigned during the pause you've received a COC on, and even those you have received COCs on, you want to go back and review those to make sure that those declarations are valid and that they've turned over everything they said they've turned over, and they've turned over everything that they have, especially where it concerns police disciplinary records or any other records. Make motions to dismiss for 3030 where applicable. Please feel free to use our affidavit, the language that's in it. People here worked very hard on that, and it's for your use. Let's not reinvent the wheel. If you don't have to, use it. And again, like I said, review your COCs for compliance with CPL 245, special emphasis on law enforcement officer records under 245.20 and the repeal of 50A. And I think that's it for this presentation. And I know there's some questions in the chat, and maybe some other people have questions now that we're finished. And I guess we're happy to take them. And I know Nick will moderate that. Thank you guys very much.
Thank you, Kevin. Thank you, Lori. Awesome presentation. Pat, would it be okay? I know we're at 3 o'clock. There are a couple questions in the chat. Would it be possible to allow those to stay on that can to hear the answers to some of these questions?
Sure. Yeah, within a reasonable amount of time. Sure.
Perfect.
We won't let Kevin answer them.
You can answer it
there. So the first question that I had, guys, it's an issue that I've come across, and I know some of my colleagues have as well. Back before the first executive order, there were cases in which the charges were filed and there was an arraignment scheduled. However, the court, due to COVID, sua sponte adjourned the arraignment. And I know in the CPL, the commencement of the criminal action for purposes of speedy trial is the filing of the accusatory instruments. So I don't know if you came across that issue, and in those cases, when would you believe that the speedy trial clock starts? Is it actually at arraignment or the date of the filing?
Go ahead, Lori.
Well, basically, it's like an appearance ticket. They file the charges, but the criminal action commences, at the arraignment. This is what we're dealing with on a lot of what we call our part twos, our non-custodial arraignments. What the district attorney's office has actually done on their own accord has been dismissing basically any vehicle and traffic 500 cases outright, so they don't have to worry about it. A lot of them are, you get the long form criminal complaints that are generally like neighbor issues or DV, where it's been determined that although the charges have been filed, if the court or the district attorney doesn't know that there have been filed, then it doesn't commence until the arraignment. We have that situation though, where the court is clearly on notice that the charges have been filed because they're the ones that administratively adjourned the 30-30. And quite honestly, we haven't had a situation where it's had to been litigated yet. But I think that's where the argument's going to be, is whether or not does the time period start when the court knows or when the district attorney knows or should have known that the charges were filed. Because with the adjournment of the appearance tickets for 3, 4, 5, 6, 7 months, where we're at right now, the district attorney doesn't necessarily know, what those appearance tickets are. Buffalo PD does, or whoever filed the long form. But I don't know if you can necessarily impute that knowledge on the district attorney.
And I guess a salient point here is that we don't get our cases until they're arraigned. So we haven't had that many, they haven't really had the opportunity to litigate that issue. I think that there's an argument to be made, though, that, with the filing of the accusatory, that's commencement. And for those of you who got those cases that were commenced but then never arraigned, I would still file your 30-30s if the district attorney's office hasn't done anything, and let them make the arguments that they didn't receive notice or that they don't have that case or whatever happened.
Well, at the very least, guys, you could argue that they received notice of the adjournment, so they know that there's a pending case.
Right.
And at that point, they could look into obtaining a copy of the accusatory instrument. And as you guys skillfully put, computers work, phones work, they can still file their COCs.
And something to keep in mind too, and this is a great example of it. We brainstorm ideas all the time. I mean, they might come flying out in the most odd, bizarre ways, but we brainstorm everything and we anticipate or try to anticipate any possible argument that the DA's office can make. We did that with our 30-30s, but our 30-30s were literally, judge, 90 days has expired, executive order, 90 days, dismiss. And we left it at that. We didn't offer anything further. Let them come up with the right arguments. And then we were, but we were always 2 steps ahead because we anticipated what the arguments were going to be. So I personally feel with the 30-30s, like something like that, I would do, bare basic and then let them try and figure out what the hell the law is supposed to be and what their arguments are.
Those are great points. Thank you. Our next question is from Luke. Luke asked, when is a COC and SOR considered served upon the defendant to stop the speedy trial clock? Is it upon an email to counsel, service upon the court, regular mail to counsel? Thank you.
The service of the COC is effective when it is received by the court. This is something else that we've been having a very interesting time with, where we're being served on like January 4th, which would be a good COC. So we're looking at it as, okay, we received it in office on January 4th. So it appears that it's a good COC, but then we find out that the court hasn't received it for 3 or 4 days. Well, you're beyond that 90 days now. So, it's when it is in receipt of the court. The other thing that we have been finding is that they're not being timestamped by the court for whatever reason, because they're, whether it's mail or they're dropping, the district attorneys are personally serving them and not having them timestamped. Technically, our argument is that COC is not valid until the judge acknowledges receipt on the record in open court that they have the COC. And, one of the pushbacks we've been getting from the district attorney's office is, well, everything's being, administratively adjourned. How do we do that? We can't do that. That's not fair. Again, telephones work, email works. I can have a case put on any docket anytime I want when the court is available. All you have to do is send an email, and they weren't taking that affirmative action. So the service on the court is the key.
Great. Thank you. Our next question is from Octavio. Octavio asks, was it constitutional in the first place for the governor to issue an executive order pausing 30-30, 180-80, and 245?
So this was an issue that was litigated very shortly after the first executive order went into effect. There was a lawsuit that was filed by one of the large institutional providers downstate. It went to the first department, and the first department found that, in fact, it was constitutional under his emergency powers. We tried very hard, and they tried very hard, especially in light of the 180/80 issue, because at that point, 30/30 hadn't really become a problem. There was still a lot of time left on any of those cases that were, or at least most of them that were filed at the time of the pause, and the ones that started getting arraigned, there would have been 90 days at least, or 30 days on those violations. So that wasn't an emergent issue, but the 180/80 and 170/70 issue was extremely emergent because you've got these clients that are sitting in jail. We work very hard to get our clients out anytime we can, and not having that tool in our toolbox was incredibly problematic. But the first department ruled in favor of the governor's office, finding that his emergency powers allowed him to do what he did, and thus his actions were constitutional. It hasn't been challenged further, to my knowledge. I don't know if an appeal was filed to the Court of Appeals and whether they're planning on weighing in on it. I haven't heard otherwise.
Kevin, do you know what the name of that case was?
Not off the top of my head. Not off the top of my head, I don't.
Okay, that was a question that just popped up while you're talking.
Yeah.
Next question, guys, is from Carla. Carla asks, I understand 30/30 is still suspended for unindicted felonies, but is 245 in effect for them? What should we do if we have unindicted felonies and no discovery is being provided and nothing is happening?
Well, so you're this is the whole catch-22 part, and this is kind of where even the misdemeanors were, obviously during the suspension. So what we're coming across right now is any felony complaint that has not been indicted, obviously 30/30 and 245 aren't really in effect. Okay, so what's happening is they still have discovery obligations, and I think there's still an argument that the discovery obligations are still there, but you can't file a proper COC on a felony complaint. You can only file the COC after the cases have been indicted or after the case has been reduced. So what we have been getting is we have been getting COCs on felony complaints that are still on the 30/30 suspension. But what we are seeing from the district attorney's office is they are putting these cases on for reduction and then declaring ready. So what you need to remember is I have a couple of felony cases that I got COCs on back in October and November. Those COCs, that's all fine and good. You have no obligation to object to those COCs or any discovery obligations under those COCs until that COC is properly held on a misdemeanor, on a converted misdemeanor information. So what happens is they reduce the felony, declare ready on the misdemeanor. Your date of readiness is the day that that reduction is done, regardless of whether or not that COC was filed 6 months ago. It doesn't matter. The reduction triggers the declaration of readiness. At that point in time, reserve your right to make the appropriate objections, which we're doing, and then you can file your objections just in the due course. That's what we're seeing right now. Unfortunately, I also have about a half a dozen cases sitting on my floor right now of clients that have, gun charges, the 26503s and whatnot, that are just in drug cases that are just kind of floating out there. And we have no teeth. We have no teeth. They can give us all the discovery they want, or none of the discovery they want. They have been providing discovery because I don't think they want to get caught again. But it is literally, I check for the new executive order 2 or 3 times a day, hoping that felony time starts running again.
Real quick, Lori, there's a follow-up question to that answer from Tom. Tom asked, but under 30/30 sub 7, doesn't the clock start when defendant appears in response to the ticket? If you have a V&T charge filed by UTT that is adjourned several months for arraignment, how can you argue 30/30?
Well, those are the V&Ts are it's a different category. And it's a different beast, so to speak. And most of them, like I said, we're so far behind on our out of custody arraignments and our appearance tickets and our traffic ticket arraignments that personally, the district attorney's office here, they're basically dismissing anything outright that's a V&T that doesn't have some sort of accident involved, a 600, a V&T 600 or something like that. In that situation, it's not necessarily the 30/30 issue. I think you have to look at the supporting deposition issue and make the supporting deposition argument at the arraignment as well. I think with the VNTs, you're in a different position where you have to wait for the arraignment to worry about the 30-30 issue. But in those situations, you're better off with your 100.25 argument that there was no supporting deposition or an insufficient supporting deposition, depending on what the facts and circumstances are.
All right, guys, one more question. This one's from Alan. Alan asked, do you have the 12/30/20 pause order for felonies? And as I was reading that, we got one more question. So after this, I'll read that last question.
I think it was included in the, oh no, we didn't include that one in the materials, did we, Kevin?
No, I didn't include it. You can find it though if you go on the governor's website. All of the executive orders that were issued during the pause are there, and just look for the one that's dated 12/30.
Great. One more question from Emily. Emily asks, for counties with a centralized arraigned part, CAP, how is the time between the CAP arraignment and the appearance in the home court charged?
To the people, because again, the clock starts at arraignment. Maybe you'll get an objection from the district attorney's office that, exactly that, that there was a delay in getting paperwork from the CAP to the home court. But I'm not sure that that's a winning argument. The people are, present at arraignment, or they get notice of the arraignment. They know that the case is now active. There's no argument that that's not commencement. So if the case is commenced, then it's up to the DA's office to then object and again, point to some 30-30G exceptional circumstance as to why they weren't able to file automatic discovery and weigh in on a COC because of a delay in getting paperwork from the CAP to the home court. Again, I think that's a losing argument, and I feel pretty confident fighting against it.
All right, that's it for questions. Thank you so much, Kevin and Lori. Amazing job, very informative and topical. Thank you so much for your time.
Thank you guys very much.
Thank you.
So our time is now expired. Thank you again to Kevin and Lori. Everyone, you'll be receiving more information about our future CLEs. And our next one scheduled for April 22nd, what every attorney needs to know about estate planning. And everyone, please be sure to send in your attorney verification form and program evaluation to Pat Warrington so that your CLE credit can be issued. Thank you very much, everyone. Take care.